Shout out madlang people. My name is Raniel C. Cortez ng PCBet 22402P. Halina't pag-usapan natin ang extinguishment of obligation, loss of the thing due ng Article 1262 hanggang 1269. Loss. It is understood that the thing is lost when it perishes or goes out of commerce or disappears in such a way that its existence is unknown or it cannot be recovered. Ibig sabihin, ito daw yung mga bagay na kino-considered na isang loss. At meron ding impossibility of performance tulad ng physical impossibility at legal impossibility na madidiscuss natin sa Article 1266. Article 1262. An obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor, and before he has incurred in delay. When by law or stipulation, the obligor is liable even for fortuitous events, the loss of the thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of the obligation requires the assumption of risk. Sabi dito, kapag ang isang specific thing ay nawala, the obligation is extinguished. Pero sabi din dito na it shall be lost or destroyed without the fault of the debtor. Meaning, dapat daw walang kinalaman si debtor sa pagkawala or pagkasira ng isang specific na bagay. At bago pa man daw nagkaroon ng delay. At meron din exemption na kapag daw ang specific thing ay nawala, the debtor does not extinguish the obligation. Ito ay when the law so provides, meaning kapag ito ay nasa batas. Second, when the stipulation so provides. At meaning naman nito is nasa kontrata mismo ng both parties. At when the nature obligation requires the assumption of risk. At lastly, when the obligation to deliver a specific thing arises from a crime na madidiscuss natin sa Article 1268. So ito yung mga instances kung saan the law requires liability kahit pa due to fortuitous event. At kapag pasok dito sa apat na to, magiging liable pa din si debtor. Next is Article 1263. In an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. Sabi dito, kapag naman nawala ang isang generic thing, the obligation does not extinguish dahil may tinatawag tayo na genus non quamperit na ibig sabihin ay the debtor can still be compelled to deliver a thing of the same kind. For example, Dodong obliged to deliver a dog to Totoy at nawala ni Dodong ang dog via fortuitous event. And Dodong still liable kasi pwede ka naman bumili uli ng another type of dog para kay Totoy. Dahil generic thing or generic dog lang naman yung hinihingi ni Totoy. Next is Article 1264. The courts shall determine whether under the circumstances the partial loss of the object of the obligation is so important as to extinguish the obligation. Ang sabi dito, there is a partial loss when only a portion of the thing is lost or destroyed, or when it suffers depreciation or deterioration. Partial loss is equivalent of difficulty of performance in obligation. For example, Dodong obliged to deliver to Arlene a specific racehorse. The horse met an accident, as a result of which he suffered a broken leg. The injury is permanent. Okay, yung broken leg, partial loss yun. Kasi hindi mo na magagamit ang isang racehorse although nag-e-exist pa or andyan pa din yung racehorse. Kasi ang purpose naman ng isang racehorse is kumarera. At paano pa kakarera kung pilay na yung paa ng isang racehorse, di ba? So, hindi na mapapakinabangan pa ni Arlene ang racehorse. Kaya yung partial loss is important as to extinguish the obligation. Next is Article 1265. Whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof to the contrary and without prejudice to the provisions of Article 1165. This presumption does not apply in case of earthquake, flood, storm, or other natural calamity. Ang sabi dito, kapag ang bagay ay nawala in the possession of the debtor or nasa mga kamay ni debtor, the debtor is presumed to be at fault. At ang sabi, presumption lang at hindi sinabi na fault na talaga. Presumption lang meaning pwede mo pang ma-overcome ang presumption. How? By providing proofs na hindi ka naman talaga at fault kung ikaw si debtor. So, parang meron lang tayong legal presumption na it gives debtor another duty to prove na hindi naman siya at fault. So, kapag nawala ang bagay sa kanyang possession, there is a presumption that the loss was due to his fault. Now, presumption absolute? The answer is no, dahil mismong nasa rule or nasa article naman din ito. It also provides more situation kung kailan hindi applicable ang presumption. Walang presumption na may kasalanan si debtor. Kasi sabi dito, the presumption of fault on debtor is not applicable in case of natural calamity. For example, Totoy borrowed the car to Arlene at habang nakay Totoy ang sasakyan, ito ay nawala. So, dito may presumption na nawala ang kotse ni Arlene at a fault dito si Totoy. Hindi pwedeng sabihin ni Totoy na, Arlene, nawala ko yung car na hiniram ko sa'yo without my fault at extinguish na yung obligation ko. Pag ganun lang, that is not enough to extinguish obligation. Totoy is presumed at fault pa rin. So, he is liable unless ma-prove niya or mag-present siya ng mga evidence na wala siyang kasalanan sa pagkawala ng kotse na hiniram niya kay Arlene. So another example, nagkaroon pala ng sunog sa bahay nila Totoy. At let's assume na yung sunog was accidentally origin. So dahil nasa bahay ni Totoy ang car ni Arlene, nadamay sa sunog ang hiniram na kotse ni Totoy kay Arlene. Pag ganito, hindi applicable daw yung presumption. Yung last sentence na sinabi ni Article 1265, walang presumption na at fault si Totoy. So, dahil walang presumption, pwede pa naman ma-prove ni Arlene na si Totoy is liable sa pagkawala ng kanyang car. Next is Article 1266. The debtor in obligation to do shall also be released when the prestations becomes legally or physically impossible without the fault of the obligor. This article talks about the loss in personal obligation. It talks about the effects of loss or impossibility of performance in personal obligation. Sabi nga, the debtor in obligations to do. So meaning in personal obligation shall be released from the liability. And so we have legal impossibility and physical impossibility without the fault of the obligor or the debtor. So dapat walang fault si debtor para ma-extinguish ang obligation. Physical impossibility takes place when the obligor dies or becomes physically incapacitated to perform the obligation. For example, Amats obliged himself to construct a commercial building to Buday. Tapos 1 week after, namatay si Amats. Obviously, as a result, he can no longer build or construct a building dahil nga namatay si Amats at wala nang gagawa sa building at the obligation of Amats has become physical impossibility. Next is legally impossibility. Occurs when the obligation cannot be performed because it is rendered impossible by provision of law, although physically it may be possible of performance. For example, hindi naman namatay or what si Amats. It's just that the government refuses to issue building permit kasi daw the area has been declared by law as a residential zone. It cannot be legal impossible kasi kailangan mo na manghingi ng building permit upang makapag-construct ng isang building. Hindi na pwede kasi ginawa na siyang residential area ng government. Kaya mai-extinguish na yung obligation ni Amats at become legally impossibility. Next is Article 1267. When the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom in whole or in part. For example, Jasmine Corp agreed to construct a road near a mountain. A very strong typhoon caused an avalanche, making the construction of the road dangerous to human lives. Although hindi siya impossible na gawin ang isang road, pero naging delikado siya kasi nagkaroon nga ng avalanche. So parang hindi inaasahan ni Jasmine Corp na gawin yung isang road dahil nga sa isang fortuitous event tulad ng avalanche. So in this case, the obligor may also be released therefrom in which whole or in part. So depende yan sa magiging difficulty ng isang area. Next is Article 1268. When the debt of a thing, certain and determinate, proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss, unless the thing having been offered by him to the person who should receive it, the latter refuse without justification to accept it. Ito naman yung epekto ng loss by criminal offense. Sabi dito, when the debt of a thing, certain and determinate, proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss. So, pag ang isang bagay ay proceeds from criminal offense, hindi ma-accept si debtor from his liability, what may be the cause for the loss, either with or even without his fault. Pag nawalang bagay is proceeds from a criminal offense, si debtor ay liable, may fault man siya or wala. At kahit pa due to fortuitous event, yung pagkawala ng bagay, magiging liable pa din at hindi ma-extinguish yung obligation ni debtor. For example, si Jojo, ninakaw niya yung sasakyan kay Mang Kanor. So ngayon, Jojo is now ordered to return the stolen car kay Mang Kanor. At bago pa man mai-deliver ni Jojo ang sasakyan na ninakaw niya kay Mang Kanor, nagkaroon ng sunog sa bahay ni Jojo at nadamay sa sunog ang kotse ni Mang Kanor. Ma-extinguish ba yung liability ni Jojo kay Mang Kanor? No, because the obligation to deliver a car to Mang Kanor is galing sa criminal offense. At in such a case, the rule is he is liable even if he lost or the loss occurs because of fortuitous event. Kahit meron or walang kasalanan si Jojo, si Jojo ay may pananagutan pa rin kay Mang Kanor. At yung sa mora accipendi naman, meaning to say na dineliver na ni Jojo yung kotse but Mang Kanor not accept or hindi tinanggap. That's a mora accipendi, delay of the part of the creditor. So, dahil hindi tinanggap ni Kanor yung car na isasoli ni Jojo, tapos after niya sanang isoli, nawala yung car, then Jojo will not be held liable kasi kasalanan ni Kanor kasi hindi niya tinanggap. But if the loss was due to the fault of Jojo, even if Kanor refuses to accept the car, Jojo is still liable. Next is Article 1269. The obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third persons by reason of the loss. For example, Amat obliged himself to deliver to Kanor a specific horse, and the horse is lost through the fault of Arlene na third person. Ngayon, nung i-deliver na sana ni Amats yung specific horse kay Mang Kanor, yung horse is nawala through the third person na si Arlene. At dahil hindi naman kasalanan ni Amats yung pagkawala ng horse, mawawala yung obligation niya kay Mang Kanor. At dahil nga kasalanan ni third person na si Arlene yung pagkawala ng isang specific horse, bali malilipat na sa kanya yung obligation to deliver a specific horse kay Mang Kanor. Yun lamang po at maraming salamat sa pakikinig. Sana may natutunan kayo at may apply natin to sa tunay na buhay. At laging tatandaan maghugas ng kamay upang hindi malos ang iyong buhay.